so many different laws and rules. And it's great that you have that available for the fitness professional community. When we were talking earlier, you said that waivers, there's a lot more to them. Where would you say fitness professionals go wrong with setting up their liability waivers? And what's a good rule of thumb that you would recommend where they can go to set one up?
Great question. And waiver law, as you mentioned, is very complex.
Yeah.
And we cover a lot of cases, waiver cases in the textbook. But it's really important to understand that waiver law is based on state law. And so you really need to know your state law, in putting together a waiver and developing a waiver. And there are certain states where waivers are against public policy, so they're not even enforceable. For example, in New York has a state statute that states that waivers are against public policy and therefore not enforceable in health clubs and fitness facilities. In another state, they might be against public policy because of a court ruling. For example, in Virginia, way back in 1992, the Virginia Supreme Court ruled that waivers for personal injuries, especially like in fitness facilities and health clubs, are against public policy and therefore unenforceable. So that's the rule or the law in Virginia, okay? So it's either by a court ruling or maybe a state statute that states that, they're against public policy and therefore unenforceable. Now that's really in a minority of states. In the majority of states, waivers, are effective in protecting defendants, managers, owners, professionals from their ordinary negligence, okay? And that's really the goal of a waiver, is to absolve the defendants of their own negligence. So if you have somebody that files a negligence lawsuit against you, that waiver might protect you, okay? And so they're very effective. However, they got to be written very, very carefully and based on state law. And so we recommend, highly recommend, that you have a lawyer in your jurisdiction, in your state, to prepare your waiver. Okay, so you make sure that it reflects state law in your state. And so I think that's really probably the most important thing, is that you want to make sure that your waiver will be enforceable if it's ever tested, okay, in a negligence lawsuit to protect you. And the other thing that I want to mention about waivers is that they protect against what we call ordinary negligence, but not gross negligence. So there's a distinction between ordinary negligence and gross negligence. So gross negligence, sometimes it's called willful or wanton conduct or reckless conduct. And let me just give you a couple quick examples, because I think that's the best way to understand. Actually, to understand the law is to review case law. That's the best way to learn the law, is to review the cases that come up, like in our field. So this was an example where a trainer had an individual perform a brand new exercise, okay? And toward the end of this exercise, he became very symptomatic. He became nauseous and lightheaded. So they let him rest a little bit. But then the trainer said, let's have you do it again, okay? Well, then when he attempted to do the exercise again, he ended up with a very serious injury. And so he sued the trainer and the club, okay, for negligence as well as gross negligence. And the court ruled that the trainer was grossly negligent because she attempted to have him do it again after she knew that he had some trouble doing it the first time. So when you know something, you know that there might be a risk, and then you don't really pay attention to that, that's an example of gross negligence. Let me give you one other really quick example, and this would be more related to management and the maintenance of exercise equipment. Okay, so in this particular case, somebody got hurt on a piece of exercise equipment, and this was a treadmill case, and the fitness facility failed to follow the specifications in the owner's manual, which required 6 feet clearance behind the treadmill. And they only had 3 feet or 3.5 feet clearance. This person fell off the treadmill, hit her head, had a severe head injury. And the court said they knew that they were not following the specifications in the owner's manual regarding clearance, and therefore they were grossly negligent. So it really comes down to prior knowledge of maybe a possible, danger or risk, and not doing anything about it, or not reacting properly to it. And that's really, what gross negligence is. And so it's important to, remember that, waivers do not protect for gross negligence, only ordinary negligence. And so another good reason to make sure your instructors and trainers and the managers are, doing what they're supposed to be doing. And so they don't have that, that liability associated with gross negligence. We have several cases in the book where the defendants were found grossly negligent. And so those are just a couple examples.